A coffee shop owner in Nashville required every barista earning $14 an hour to sign a non-compete agreement prohibiting them from working at any competing coffee business within 15 miles for 2 years after leaving. For 3 years, that agreement sat in a drawer. Then a former barista got a better job at a competitor down the street. The owner sued. The court declined to enforce the agreement. Courts in most jurisdictions will not enforce a non-compete that is disproportionate to the business interests being protected. Most business owners do not know where the line is. This is where it is. In April 2024, the Federal Trade Commission issued a final rule that would have banned non-compete agreements for virtually all workers in the United States, an estimated 30 million people. The rule required employers to void existing non-competes and notify affected workers. The only exception was for senior executives, defined as workers earning more than $151,164 annually in a policy-making position, who could keep existing non-competes but could not have new ones added. In August 2024, a federal district court in Texas set aside the FTC rule, holding that the FTC lacked statutory authority to issue a categorical ban on non-competes. The court applied the major questions. Doctrine, a principle established by the Supreme Court in West Virginia v. EPA that requires clear congressional authorization for agency rules of major economic significance. The FTC's non-compete ban was found to be exactly that kind of major rule, and the court concluded Congress had not given the FTC authority to enact it. The rule never took effect. With the federal rule blocked, non-compete enforceability is entirely a matter of state law, and the variation is substantial. California has banned non-compete since 1872. Minnesota and North Dakota have had broad bans for years. Oklahoma prohibits most non-competes. About a dozen other states have passed significant restrictions in the past 5 years, including limitations on the workers and industries to which non-competes can apply, and caps on the duration and geographic scope considered reasonable. In states where non-competes are permitted, enforceability depends on 3 factors: legitimate business interest, reasonableness of scope, and consideration. A legitimate business interest means you are protecting something specific, trade secrets, customer relationships, or specialized training you have invested in. Reasonableness of scope means the geographic area, duration, and activity restricted must be proportional to what you are protecting. A 2-year 50-mile restriction for a senior sales executive with direct customer relationships is very different from the same restriction on a warehouse worker. Consideration, meaning what the employee receives in exchange for signing, is critical and frequently mishandled. A non-compete signed at the start of employment is generally supported by the consideration of the job offer itself. A non-compete handed to an existing employee on a Tuesday with no accompanying raise, promotion, or other benefit may lack consideration and be unenforceable. Several state courts have held that continued employment alone is insufficient consideration for a non-compete presented after the employment relationship has begun. The more durable approach to protecting legitimate business interests is a combination of 3 agreements. A confidentiality and non-disclosure agreement protects trade secrets, client lists, proprietary processes, and confidential business information, and unlike non-competes, NDAs are enforceable in virtually every state. A non-solicitation agreement prohibits a departing employee from approaching your customers or recruiting your staff, narrower than a non-compete and significantly more likely to survive judicial scrutiny. Trade, Secret protection under the Defend Trade Secrets Act of 2016 provides a federal cause of action against misappropriation. If you are in a state that still permits non-competes and you want to use them, restrict their scope. Cover only the specific roles and geographies that reflect actual competitive risk. The broadest enforceable restriction is usually narrower than the one business owners instinctively write. Courts in states that do not ban non-competes outright still review them for reasonableness, and an overreaching agreement is more likely to be voided entirely than narrowed by a judge. Some states will blue pencil, meaning rewrite to the enforceable scope. Others will void the entire clause. If you are an employer who has required low-wage workers to sign non-competes, review those agreements now regardless of what any federal rule says. Many states have recently passed laws prohibiting non-competes for workers below certain wage thresholds. Illinois, for example, prohibits them for workers earning under $75,000. Massachusetts prohibits them for non-exempt employees. Using a non-compete that a court declines to enforce wastes legal fees and damages employment relationships. Relying on a void agreement for protection you do not actually have is worse. Review every non-compete you currently use or have employees sign. Know what state law applies. If you have employees in multiple states, that answer is different for each state. Replace overly broad non-competes with targeted NDAs and non-solicitation agreements. If you are relying on a non-compete to protect genuine trade secrets, consider whether trade secret law or a well-drafted NDA might provide more reliable and more defensible protection. The workers most likely to harm your business if they leave are also the workers most likely to have the resources to challenge an overreaching restriction. If a non-compete is the wrong tool, a precise NDA is often the right one. Non-disclosure. Agreements for small businesses, what they actually protect, breaks down how to write one that actually holds up. It is on this channel.